And counsel, would you identify yourselves for the record?
Stephen Stubbs. I do have a bar number 10449, but I'm here in proper person.
Okay.
Craig Anderson and Jackie Nichols, and with us is Judge Victor Wilker.
Okay. Good morning. All right, and this is plaintiff's motion to place a petition for writ of mandamus on calendar, and of course we have. And I did get a response from Boulder City Municipal Court, Judge Miller, and then we did get a reply, Mr. Stubbs, but we got it this morning, so I'll be perfectly frank, I have not had an opportunity to review it.
Okay, I'll go through it then, Your Honor.
Okay. Now, I'm going to have a chat with the other side in just a moment, but they have pointed out that you sued Judge Miller individually.
And I did not, Your Honor. That's what's in the caption. I apologize for not making it more particular in the caption, but if you'll see the first page of the petition, it's clearly directed to Boulder City Municipal Court Judge Victor Miller. It's in his capacity as a municipal court judge. In addition, from the NRS 34.150 to NRS 34.310 disclosures, it says many times, Victor Miller, judge of the Boulder City Municipal Court. So even though the caption is incorrect, and I did apologize in my reply for the confusion with the caption being incorrect, the substance of the petition is proper.
Okay. Should you have also included Boulder City Municipal Court in general?
I don't believe so. He is the judge of the municipal court. He's the only judge of the municipal court. I don't believe that's necessary.
Okay, fair enough. All right, I'll listen to you, Mr. Stubbs.
Thank you, Your Honor. May I use the podium?
Absolutely, it's your show.
Thank you very much. Your Honor, I'm going to give a short introduction, and then I'm going to map out the law, which with the history of the law, it's a little convoluted, but I hope to clarify that for Your Honor.
And to assist you, I did read everything.
Except for my reply.
Except for your reply.
Yes, this is what I do in the reply,
Okay.
Your Honor. Okay. And then I'm going to apply those facts, Your Honor. And as a short introduction, let's talk about what this is not. This is not a contempt hearing. Judge Miller is trying to make this a contempt hearing to where Your Honor would decide whether I'm in contempt of his gag order. That is not proper, and that is not proper according to the Nevada Code of Judicial Conduct 2.1, as Your Honor is only permitted to rule on things before Your Honor and not to interfere in other cases, which would include the municipal court case. If Your Honor finds that this gag order does not violate the First Amendment and upholds this gag order, Judge Miller can certainly find me in contempt. I would hope he would give me a hearing. I would ask for a hearing because I have explanations for everything that he's presented. But this is not a contempt hearing, and frankly, Your Honor, I think it's improper for them to try to make it so. I'm here exercising a constitutional right, and for them to try to threaten me with coming here and being jailed for specifically 25 days, it's wrong. It is just wrong. It's intimidation, and it is plain wrong. And I hope Your Honor will not turn this into a contempt hearing, and that you'll simply hear my plea for my First Amendment rights to be reinstated according to the petition of the writ. Now, it's also important to point out that this is a writ of mandamus. This is not an appeal of the Boulder City Municipal Court. It is a separate and distinct action to determine whether, and the only question between Your Honor, is whether Judge Miller's gag order violates my First Amendment rights. And in summary of what will be argued here, the speech here, my speech, is clearly political speech. The Supreme Court calls that pure speech. There is only one thing that trumps pure speech, which is the Sixth Amendment right to a fair trial by jury, which is analyzed in Gentile. So it is the second highest of all protected rights under the Constitution. And it deals with my criticisms of a public official, Steve Morris, and the prosecution of a criminal case, which Gentile deals with as well. There is no jury in this trial to be tainted. It is a bench trial where the only finder of fact is Judge Miller. I would submit that Judge Miller's gag order is not narrow enough. And it is not the least restrictive means. We're talking about the trigger for this was a Facebook post, my personal Facebook post. We're talking about Facebook and YouTube. The least restrictive means for Judge Miller, the only trier of fact, to not be tainted by anything I say about his Mormon stake president, which, by the way, I am also a Mormon, proud Mormon, an active Mormon, is to not look at my Facebook page.
I do have a question. I thought I read somewhere that you were posting on a community board. I don't know if it was
Yes.
a Facebook or something like that.
It was shared. However, as soon as this was the gag order was put on, I simply changed the settings on Facebook. Now Judge Miller, even if I post on any boards, cannot see anything I post, anything I comment, anything I like. Facebook has completely restricted Judge Miller's view, which that little click, Judge Miller could have done that too. I did it because I realized that this was now an issue. I did it. But the least restrictive means for the only trier of fact here to not hear what I am saying and have it not affect the misdemeanor trial is simply clicking on Facebook. And then, of course, him not going to my YouTube channel, which I'm sure, I don't know if he's ever been there or not. But what was triggered here, this was from Facebook. Now, we're dealing under map of the law. Gag orders are prior restraint. We are dealing with prior restraint. The bar ethical rules, dealing with extrajudiciary statements, is also prior restraint. Gentile is the controlling law for attorneys, specifically attorneys participating in public speech, and prior restraint. Gentile is the controlling law here. Now, interestingly, Gentile and the United States Supreme Court calls prior restraint, quote, evil. They call it evil in all respects, not just the attorney's prior restraint. Evil. But they say it's necessary. It's necessary when it could alter the Sixth Amendment right to a fair trial by jury. And so gag orders can be correct against attorneys, right? If they meet the Gentile test, if they're narrowly tailored, and if they're the least restrictive means. However, they are presumed unconstitutional. Me simply saying, hey, this is a First Amendment issue and looking at it and pointing out that there is prior restraint involved, this gag order is presumed unconstitutional. Now, Judge Miller must rebut that presumption. He must rebut that presumption. He says that he has to rebut it by the Levine test from 1985. I don't believe that's true. Now, pre-Gentile, which was 1991, the general test for prior restraint for the entire Ninth Circuit was Levine. And that's from 1985. But it dealt with everything, absolutely everything. And there was the Levine standard was the clear and present danger standard. Now, what that standard says is that the activity restrained, or in this case would be my speech, if it poses a clear and present danger or a serious and imminent threat to a protected competing interest, and the order is narrowly drawn, and it is the least restrictive means, and other less restrictive means are not available, then it is proper. That is the only way under the 1985 Levine test that Judge Miller can rebut the presumption of unconstitutionality. However, in 1991, Gentile specifically overturned the clear and present danger test, dealing with attorneys, and then I would also say, it doesn't say specifically, but I would also say dealing with attorneys exercising political speech or pure speech. Okay, so specifically dealing with Gentile, the court noticed that there were other jurisdictions and other circuits that were using a different test. And they thought that test was the most proper test. So Gentile overturned Levine. Now in U.S. v. Brown, they also confirm, and that's a Fifth Circuit case, that Gentile overturned Levine dealing with attorney speech. And we'll get to that in just a moment. But under Gentile, this was a case where Dominic Gentile made some extrajudicial statements.
I remember that. You got to remember, I was in practice back then. I was
Awesome.
a seasoned lawyer by then.
There you go.
91.
Dominic Gentile went to the press and made some extrajudicial statements in a jury trial. Now, this was a jury trial, unlike my case. But in a jury trial, and the State Bar of Nevada disciplined him for it, and the United States Supreme Court took up the case. Dominic Gentile specifically called out the prosecutors and called out the police for corruption. Pure political speech. That's what Dominic Gentile did.
By the way, did you know that Judge Timothy Williams wrote the brief to the U.S. Supreme Court on that?
I did not know that.
You do now.
I do now. I absolutely do now. Okay. And Your Honor, under the Gentile test, the Supreme Court says that to rebut the presumption, the state has to show a substantial likelihood of material prejudice. Now, this is different than the other. The other does not have the word material, but a substantial likelihood of material prejudice. This is a different bar to clear, very different. On one end, he has a lesser standard, to a smaller bar to clear, to where it's the substantial likelihood instead of clear and present danger, which is a much higher standard, okay? But also of a material prejudice. It is allowed to be a normal prejudice, but it cannot be a material prejudice. And in that case, the court focused on tainting a jury. The entire case, 20 pages, was analyzed of Dominic Gentile's public speech, his pure speech, and its availability to taint a jury. That was the entire focus. And I will say, of the 3,067 cases that cite to Gentile, I looked at over 300 of them. I didn't get to all 3,067 in a day and a half. But there was only one case that I was able to find that did not deal with the tainting of a jury. And I'm going to talk about that case. It's the Scarfo case in the Third Circuit, which is very important here. But they concentrated on the tainting of the jury, and they focused almost entirely on the importance of Gentile's speech and Gentile calling out the prosecutor and calling out the police in a criminal action. It's in the reply, and since Your Honor has not read that, I'm going to read from parts. Gentile explained that the standard is designed to protect the integrity and fairness of a state's judicial system and impose only narrow and necessary limitations on lawyers' speech. Narrow and necessary. Requoting. Those limitations are aimed at comments that are likely to influence a trial's outcome or prejudice the jury. Veneer. Even if an untainted panel is ultimately found. Few interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors. And the state has a substantial interest in preventing officers of the court from imposing costs on the judicial system and litigants arising from measures, such as a change of venue to ensure the fair trial. The restraint on speech is narrowly tailored to achieve these objectives, since it applies only to speech that is substantially likely to have a material prejudicial effect, is neutral to point of view, and merely postpones the lawyer's comment until after the trial. In interpreting the substantial likelihood of a material prejudice, of an adjudicative proceeding, one central point must dominate the analysis. Here's the central point. Whether the case involves classic political speech. That is the center of the analysis. Whether the case involves classic political speech. The U.S. Supreme Court draws a distinction between normal attorneys speaking about their cases, whether they're soliciting clients, making a joke, doing anything just that normal attorneys do. And, quote, words directed at public officials and their conduct in office, explaining the dissemination of information relating to the alleged government conduct has, quote, traditionally been recognized as lying at the core of the First Amendment. The core of the First Amendment. I have to find my place again. It would be difficult to single out any aspect of government or higher concern and importance than the manner in which criminal trials are conducted. Public vigilance serves us well for, quote, the knowledge that every criminal trial is subject to a contemporaneous review in the public forum of public opinion is an effective restraint on possible abuse of judicial power. The court is encouraging attorneys to speak out here, encouraging them. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. Public awareness and criticisms have even greater importance, whereas here they concern allegations of police corruption, same in my case, or where, as in also the present circumstance, the criticisms question the judgment of an elected public prosecutor. They specifically call out and are asking attorneys to be a check on the government to do pure public speech, and they say specifically it's important when you question the judgment of a prosecutor. Our system grants prosecutors vast discretion at all stages of the criminal process. The public has an interest in its responsible exercise. The substantial likelihood of material prejudice test should be interpreted in a proper and narrow manner. Restrictions on an attorney's speech cannot be greater than is necessary or essential to the protection of a particular government's interest, in this case, jury trials. And it should be noticed that the U.S. Supreme Court analysis of the facts in the Gentile centered around the influence of the jury. Now, that's the Gentile standard. That's important. And the Supreme Court is essentially asking attorneys to stand up, saying how important it is and how we as attorneys are an important check on the judicial system, especially, I bit the inside of my lip. Oh, wow. Especially when we're questioning the prosecution's actions. That's what Gentile says. That is the Gentile standard. Now, in Johansson in 2008, it was a case to where the Nevada Supreme Court adopted the Levine standard, but there was no attorney challenging the gag order at that time. In fact, the court specifically talked about how it was participants in their own case. So I would submit to Your Honor that the United States Supreme Court case, Gentile, controls prior restraint dealing with attorneys, and specifically attorneys participating in public speech, pure speech, and especially if they're criticizing, according to the Supreme Court, either the police or the judgment of the prosecutor. The Supreme Court is clear. And then Johansson adopting, now let's talk about that. It adopted the Levine standard. Why did they use the word adopt? If that was the standard since 1985, why would there be a need for the Nevada Supreme Court to adopt it? There wouldn't, because it would have been the standard. But the United States Supreme Court specifically uses the word adopted to where in Johansson, they adopted the Levine standard. And I've presented the Levine standard to you, Your Honor. And I'd even submit that I passed that too. But the Levine standard does not deal with the standard in Gentile that specifically addresses the exact type of speech that I've participated in. Now, Your Honor, this isn't my first rodeo. For the last 5 years, almost 6 years, I have been an active advocate against police and prosecutorial corruption. I have a YouTube channel that has almost 3 million views. I have a Facebook following. I have all these things. And when I talked to the State Bar of Nevada, we went over Gentile. And we agreed that if I will stay in my little circle of non-jury trials and pure political speech, I'm safe. I'm safe under the safe harbor rules.
You mean in terms of the professional rules of
Exactly.
responsibility?
Exactly. And the prior restraint that would be exercised by the State Bar of Nevada. In fact, just 2 weeks before this gag order, Deputy District Attorney Michael Dickerson, in front of Judge Zimmerman, asked for a gag order in a similar type of case, and Judge Zimmerman shut it down wholly because it's political speech dealing with a non-jury trial. And that case is the State v. Trice Rasul, TYRICE RUSSELL. The case is still ongoing. But even prior to that, Judge Cicento, in a temporary protective order hearing, it's actually the same type of case. Las Vegas Metropolitan Police Department asked for a gag order against me and my client with Judge Cicento. And Judge Cicento said, no way. He said, what is the difference between Mr. Stubbs posting things on his YouTube channel or the Las Vegas Review-Journal printing something? He said he was not going to touch the First Amendment issues, right? I've been dealing with this for 5 to almost 6 years, Your Honor. And this is the first time anybody's actually issued a gag order. And I believe I'm on strong ground, and I believe I understand things very, very clearly. Now, to support the fact that Gentile controls attorney prior restraint, especially with political speech, the Third Circuit has weighed in. The Fifth Circuit has weighed in twice. The Sixth Circuit has weighed in, and the 11th Circuit has weighed in. The Ninth Circuit has not had a case yet. Neither has the Nevada Supreme Court. Neither has a district court that I am aware of since Gentile. But they have all cited to Gentile and held Gentile out to be the controlling law dealing with prior restraint and attorneys. There are 3,067 citations to Gentile in Westlaw. Now, the most important of those cases is the Third Circuit Scarfo and the Fifth Circuit Brown. Scarfo, of all the cases I was able to look at and go through, Scarfo is the only case I found that dealt with no jury. In Scarfo, it was a defense attorney that had already completed his trial, and there were post-conviction issues. He made a statement to the press. The press printed that statement, and the higher court, the appellate court, issued the gag order. There was no jury in that case. And once again, they adopt Gentile. The Third Circuit adopts Gentile. And in Scarfo, they specifically talk and specifically address the judge in the case, and they specifically say, and I quote, and I'm going to quote this because
It's on page 6 of your reply.
Yes, it is. There is no risk of prejudice to the judge. Let me repeat that. There is no risk of prejudice to the judge because judges are experts at placing aside their personal bias and prejudices, however obtained, before making reasoned decisions. Judges are experts at closing their eyes and ears to extraneous or irrelevant matter and focusing only on the relevance in the proceedings before them. The district court did not articulate any specific or general prejudice it would suffer, and we can see none. The closest the court came to identify prejudice was its statement that, quote, I was concerned whether we talk about how I felt, orderly presentation of significant important arguments by counsel. The district court appears to have been upset about reading of a matter pertaining to a case before him in the newspaper before the hearing about trying the motion in front of the press. His concern does not rise to any measurable level of prejudice. A perturbed judge is not necessarily a prejudiced judge, especially when, as in this case, he is an experienced judge. Scarfo nails this issue, nails it right on its head. That if the jury isn't going to be tainted, if the jury pool is not affected, then it is not proper. And it's the only case, and it happens to be a Third Circuit Court of Appeals case in Scarfo. Now, then there's Brown. Brown specifically says that Gentile overturned Levine. Brown expands that and says that, and I agree with Brown with that. But Brown dealt with a public official. And the lower court issued its gag order, and they lifted the gag order entirely, gave, quote, unfettered speech. Unfettered is the quote. During the election cycle, that's how they narrowly tailored it. And they recognized the importance of political speech. And so during the election cycle, the lower court allowed for all speech. The entire gag order was lifted. They also provided other avenues of expression. Where's my other avenue of expression? But here, other avenues of expression. And that's a Fifth Circuit case. Now, that gag order was upheld specifically because of the likelihood that it would taint a jury. But unlike Brown, there is no jury in my case. And Gentile controls. Johansson is distinguishable because it's not dealing with the attorney and it's not dealing with political speech, and it's a broad standard, which was the Levine standard before anyway. Gentile only overturned Levine to the effect of attorney speech. In fact, they even talked about how courts can hold attorneys to a different standard. And in fact, that's most of the citations that are in the 300 that I looked at, dealt with the fact that attorneys can be held to a different standard than the general public because we are officers of the court. And I recognize that. But I've always stayed in my circle. I've always stayed in my circle of public speech, pure speech, no juries. I wouldn't dare try to taint a jury. I find that offensive. I wouldn't do it. I think it's wrong. And I didn't do it here. Now, Your Honor, let's talk about the facts of this case. I was dismayed when I read the response. I was disheartened to see that Craig Anderson is the attorney that Judge Miller hired to represent him here. Why? This case has a companion civil case in the federal court. Guess who that attorney is for the city of Boulder City? Craig Anderson. Now, the city of Boulder City and the judge in my criminal case have a common attorney, which makes it impossible to go around any ex parte rules. Judges, unlike attorneys, are under a heightened rule to where anybody under their control and their actions are attributed to the judge. So, if everything is attributed to everybody under his control, that means that by law, if the city attorney is talking to their own counsel, Craig Anderson, about the facts of this case, they are talking to Judge Miller. It's ex parte. And there's a litany of other rules of professional conduct for judges that come into play here. There's 6 of them, all because Judge Miller decided to hire Craig Anderson. The only declaration they attached, Your Honor, was the declaration of City Attorney Steve Morris. Why in the heck are they working together on this? The trial in the criminal case with my client is not until May 23rd and 24th. So why is the city attorney specifically working together with Judge Morris against my client's attorney and my client? Not only that, but Judge Miller, in his response, adopted the exact facts of what allegedly happened with my client that's at issue in the criminal trial that the city alleged in their motion for summary judgment. Page 3 of my reply. Highly prejudicial and damning facts to where Judge Miller is declaring my client guilty in a case that he is overseeing. This is ridiculous. This is so wrong. And adopting verbatim, the facts from the motion for summary judgment before trial? My client cannot get a fair trial here because of Judge Miller and because of Craig Anderson.
Well,
he's guilty.
Well, Mr. Stubbs, those issues are not before the court. The issues before the court are your First Amendment petition.
You're right, Your Honor. However, the point is Judge Miller has thrown in the wastebasket all of the canons of judicial conduct and the First Amendment in this case. He's thrown that in the wastebasket. And it's proven by his response and how he chose to respond, declaring my client guilty before trial. Those are the ethics of this man, who is a man that I used to look up to. I used to look up to him. He was my youth leader in church, for heaven's sake. As a 12-year-old kid, we went to the lake together. We went to the temple together. We went all over the place. And this is what he does? The facts of this case are a First Amendment case where my client was legally walking in a crosswalk to protest an enforcement event by multiple law enforcement. He walked legally, and it made John Glenn, a sergeant, mad, and so John Glenn falsely arrested him, and we're alleging that he falsified evidence, and there is extreme corruption in this case. And the city charged him with some crimes. A surveillance video came out, and as soon as the surveillance video came out and showed that all of the cars yielded to my client, because the charge was stepping out in the crosswalk in a manner where it's impossible to yield. As soon as that came out and showed and proved that everybody yielded, it was dropped, dismissed. There was still the statute because it was dismissed pursuant to statute, so the statute of limitations applied. And my client sent all these videos to experts and found discrepancies that could not be ignored. And because of that, in May of 2017, we filed a federal lawsuit. Then they hired Craig Anderson. Then they refiled charges and they upped the ante. They added an obstruction charge specifically for walking in the crosswalk during the enforcement activity. Now that's important, Your Honor, because it goes to the heart of my speech that Judge Miller found so offensive. Because I made a Facebook post that simply showed the press release, a public record, from the Boulder City Police Department instructing everybody to walk in the crosswalk, and then showed a cropped, the crop for the exact charge in the complaint for obstruction that charged him simply walking in the crosswalk during the enforcement event. And I said the words, City Attorney, Boulder City City Attorney Steve Morris does not care about the First Amendment. That is what happened at Facebook. That is what happened. And that is what set off Judge Miller. And that was the crux of this gag order. And unfortunately, Your Honor, Judge Miller and Steve Morris, they have another conflict, as Steve Morris is Judge Miller's LDS Stake President. Now, I set this out in my petition, and I would note that none of it has been challenged, not one word of it has been challenged, of the positions of Judge Miller versus his LDS Stake President, Steve Morris. Because under Mormon doctrine, Steve Morris has authority to receive prophecy and revelation for everybody within his stake, including all of Boulder City and including Judge Miller. Now, I took offense to that, and I was planning on speaking the next Tuesday in the City Council, both about this issue here that I've just addressed, and Steve Morris continuing to violate the First Amendment by continuing to move forward with the charge, and also the fact that there's a conflict of interest in that relationship, to where the prosecutor is the spiritual judge in Israel. That's the quote, spiritual judge in Israel of Judge Miller. You know, maybe that doesn't make it any difference with a law argument. Maybe it doesn't make a difference with a fact argument, but it certainly makes a difference with a moral argument. And how is it fair for anybody to face a moral argument where the person on the other side has moral and religious authority and the authority for prophecy and revelation over the judge? So I wanted to talk about that. But Judge Miller issued a gag order, a broad gag order that included both me and my client. And on Monday, he called me ex parte at my home, and he threatened me, and he said that I had to shut up my client's father, Ainsworth Hunt.
Objection, Your Honor. I know I'm not the attorney here, but there is nothing we've been presented to show anything about this conversation. Steve's
It's
a
true.
friend.
Well,
We've had many conversations over the years, and I object to the hearsay nature of this.
I understand. I'm
That's
gonna go ahead.
improper.
I am going to listen.
Okay.
But I'm going to listen fully to both sides.
Of course. He threatened me. And he says, I guess I need to include Ainsworth Hunt in the gag order too. Phone records will show he called me. My wife was sitting next to me during the entire thing. It was an improper ex parte communication to where he threatened me. And I called his bluff. And I said, you better look at the Gentile case, because I'm going to sue you. If you include Ainsworth Hunt in this, he's going to sue you. He even said, does he want me to recuse myself from the case? And I said, he doesn't think you should be a judge. But Judge Miller threatened me. He threatened me. And then, an hour and a half before, on Tuesday, an hour and a half before the hearing that I wanted to speak at, he issues his written order. Now, before that is this broad order, this very, very broad order, to where he threatened to attribute anything that Ainsworth said to myself, which would be improper. An hour and a half before the hearing, he sends out this gag order, which is less, but it's still not proper. But he accomplished everything he needed to because he protected his stake president. Now, under Mormon doctrine, and I cited to this in my petition, it is improper. An apostle to the Lord in the LDS Church, Dallin H. Oaks, said that it is improper to criticize a church official even when they are wrong. That is what Judge Miller took offense to. That is what happened here, and that is the sole purpose of this gag order. Judge Miller cannot stand the fact that I am criticizing his LDS Stake President. Mission accomplished. He was able to keep me an hour and a half before the hearing. It's not, I can't prepare anything in that time. And do you know what? At that hearing before the Boulder City Council, Steve Morris got his permanent contract, and he broke a record for the amount of money that was paid for that permanent contract. My speech was suppressed. That is what happened, and that is what this is all about. Now, excuse me. Your Honor, I filed this writ. And I'll now apply both the proper law and the improper law that they state. I will now apply that to the law as and I'm making a formal objection, by the way, to Mr. Craig Anderson being here. I do not think that is proper at all. There is no likelihood whatsoever under Levine or under Gentile that what I say will have any influence on Judge Miller, and I would even say in the courtroom. Why? Because Judge Miller has already made up his mind. How do we know? He told you in his response what the facts of the case are before trial. He's going to listen to his stake president. He has already made up his mind, and he put it in writing that he is adopting the facts before trial that the city put in their civil motion for summary judgment. Therefore, there is zero likelihood that anybody can have a fair trial in front of Judge Miller, and anybody can change his mind. Much less a substantial likelihood that my simple Facebook page will prejudice the proceedings. There is none. Additionally, he's a judge. Why is he following me on Facebook anyway? There is no substantial likelihood because this is a bench trial. Gentile deals with a jury. Every case I know of, and there are 3,067 total out there, deals with the jury. And the one case, Scarfo, the one case that says, or where the facts are that there is no jury involved because the jury has already declared their verdict. The one case says this doesn't apply because there's no jury. There's zero likelihood of it affecting a judge. Also, according to Brown and Gentile, we have to look at the pure political speech. This was not narrowly drawn. This could have been drawn up like Brown is, to where Judge Miller said, okay, you are not allowed to talk about the attorneys in the case except public speech. He could have said that. That would have been narrowly drawn. That would have been in line with Gentile, except for the jury part. But if we get past the jury part, he could have narrowly drawn it. He did not narrowly draw it. And my speech is pure speech, just like Gentile. My speech is non-jury trial, specifically criticizing Steve Morris and Gary Booker as well. He's not a public figure, but he's also a prosecutor, and how they're handling this important First Amendment case of whether or not somebody can protest by legally walking across the street in a crosswalk. That's an important case. And I'm offended at the way they're handling this. And according to the Supreme Court, it's my responsibility to speak because it's an important check on the government. And do you know what? Maybe they'll reassess and say, let me look at the First Amendment. Do you know what? Maybe I shouldn't have charged obstruction, and we'll just deal with the other ones. Maybe they'll do that. That would be a good thing. And if I have that effect on them, that doesn't materially prejudice me opening their eyes to a First Amendment issue does not materially prejudice anything. It helps justice. I'm trying to promote justice. My words are promoting justice, the exact opposite of either the Levine standard or the Gentile standard. I am promoting the First Amendment. Judge Miller tries to bring in the fact that there's a jury in the civil case and tries to bring that in. That is improper for a number of reasons. First of all, Steve Morris is not involved in that case. He's not a witness. He is not a party. He has not been deposed. His actions are not at issue in that case whatsoever.
Now, that case, you're talking about the action against your client's action.
My client's federal First Amendment, civil rights action against the city of Boulder City, that in Judge Miller's gag order, Judge Miller tries to bring in and say, I'm going to use that jury there as reasoning for issuing this gag order.
Okay, I wasn't sure whether you're talking about the criminal action against your client
No,
or
it is not the
civil
criminal
rights.
action. It's the civil rights action. Judge Miller has a very limited jurisdiction. It's a municipal court. He has a jurisdiction for the municipality and what is before him in that municipality. It is both a violation of the second canon for him to usurp the federal case or the facts of the federal case or interfere in any way with that federal case. It is against his judicial canons for him to try to usurp that and say, oh, there's a jury in another case, so I'm going to issue a gag order in this case where there's no jury. That is improper and it is unethical. It's wrong. And Steve Morris isn't even a party. None of it. Now, Judge Miller is also right now a public official. He is a public official himself. And he is also running for re-election. That opens up the judicial canons of 4, dealing with when he is a candidate running for office. He cannot say anything or rule on anything that might affect any case that's not before him. You tell me how this doesn't affect the civil case if he's specifically saying that he's doing this because of the civil case. He's thrown his ethical canons in the garbage. Now he's putting the lighter fluid on it, and he lit a match. Completely improper. 100% and completely improper. His jurisdiction is set out in NRS 5.050. And that jurisdiction deals specifically with the municipality and the municipality only. Inside Boulder City, not in this federal court over here. That's all he has the power to do as a municipal court judge. That's it. But he tries to usurp other authority. And with all this analysis, and with the fact that he has to use the least restrictive means, with all this analysis, all he has to do is stay off my Facebook and YouTube. All he has to do is change the settings so he can't see anything that I say. That's it. That is the least restrictive means. That's all he has to do. All. This is preposterous. I'm well within my rights and my expression rights under the First Amendment. I am well within, with no jury, and criticizing public officials that were about to be appointed permanently. That the matter was before the city council. But Judge Miller wants to protect his stake president because as Mormons, we're ordered by our apostles not to criticize our leaders, even if they're wrong.
Mr. Stubbs, you're getting where you're repeating yourself.
And I'm setting up, Your Honor, I'm setting up the fact that when this came out, my own father, this is at enormous cost to me that I'm making this stand. enormous personal cost. Because not only did the Mormons of Boulder City that used to be my friends blow up my phone with how they can't talk to me anymore, they can't be my friend anymore, but my own father sent me a text message declaring me an apostate and ordering me to submit to the priesthood and submit to Stake President Steve Morris. I didn't talk to my father for 2.5 weeks until my mom could broker a deal to where we don't talk about it. This stand is at an enormous cost to me, and I believe in it, and it's my right. And Steve M. Morris and Judge Miller interfering in this is wrong. Them being the same, having the same attorney and being together in this is wrong. Steve Morris making a declaration and working with Judge Miller on this action is wrong. Thank you.
Thank you. Counsel?
Thank you, Your Honor. Although it's not relevant, I do want to clear up just a couple of things. I was retained in this matter by the City of Boulder City Municipal Court, the City of Boulder City, to review this order. I don't have it play any role in the criminal case. I was told to review this order and then handle this writ issue. The facts that we put in the order to give this court context in our response were taken from plaintiff's own deposition, Mr. Hunt's own deposition. Okay, it's an interesting case. They've got a civil case going with a criminal case. They didn't want to stay it. Never seen that before, but we went with it. So the facts that are included in the motion that we drafted were put by me, but they are John Hunt's facts. They are not an adopted, slanted set of facts. We carefully took the facts from his deposition and put them in that motion. So that's all they are. They were just to give the court context. Judge Miller did not have any role in drafting the facts. I hadn't talked to Judge Miller about this. I read the order. We obtained an affidavit from Steve Morris just pointing out that he's not trying this case. Gary Booker is. He attended one hearing. Steve Morris attended one hearing, and that was because there was an accusation of prosecutorial misconduct. It's his department. It's his job. He showed up as he should. So I don't know the basis for a lot of the stuff that was said here or the facts going on. This is a very limited issue before your judge. The issue is whether Judge Miller's order that says the following: all counsel and parties are prohibited from engaging in extrajudicial communication that in any way disparage or otherwise comment on opposing counsel relevant to the case. Kind of a plain nice order, quit insulting each other. Now, Mr. Stubbs he ignores anything that's not beneficial to him. So he comes in and says, this is not going to prejudice Judge Miller. Judge Miller never said that this was so he wouldn't be prejudiced. He cited to the candor to the tribunal, the fairness to opposing party and counsel, prohibition on conduct intended to disrupt the tribunal, and trial publicity. He didn't say this is influencing me. He said it's not good for Boulder City. It's not good for the community to see this, which is exactly what the Supreme Court has stated. The Supreme Court has stated,
Are you looking at Gentile?
Yeah, well, I was actually looking at Levine, where the Supreme Court has suggested that it is appropriate to impose greater restrictions on the free speech rights of trial participants than on the rights of non-participants, and that's Shepard versus Maxwell. And then also, in the case for restraints on trial participants is especially strong with respect to attorneys. We heard a lot about Gentile. Gentile is not applicable to this case. Gentile was not a prior restraint case. It was a discipline case about whether that violated the First Amendment. The Ninth Circuit Levine case was 1985. Then in 2008, the Nevada Supreme Court adopted the Ninth Circuit standard in 2008, so 17 years after Gentile. Mr. Stubbs says he doesn't understand why it was adopted. I don't understand that argument. The Nevada Supreme Court has to adopt what the Ninth Circuit does because it's not binding on it. The primary case cited in Mr. Stubbs' reply that he kept referring to, this Brown case, okay, that was a 2000 case. So 8 years before Johansson, before the Ninth Circuit, or before the Nevada Supreme Court adopted the Ninth Circuit. In Brown, he says it overruled Levine. That is not true. Here's what it says. We decline to adopt the more stringent tests advocated by the 6th, 7th, and 9th Circuits. So it's a 5th Circuit case that says we don't agree with the 9th Circuit. Well, the Nevada Supreme Court did, and they adopted it. And that's the standard we're here on today, is the Levine standard adopted by Johansson. And so looking at the Levine standard adopted by Johansson, there's 3 issues that Your Honor has to decide. Whether the activity poses a clear and present danger, that's the first one. The second one is whether the order is narrowly drawn. And the third is whether if there are no less restrictive means available. When you look at the simplicity of Judge Miller's order, he did just that. It was a very carefully drafted order to stop this mudslinging and calling names, calling the district attorney an idiot, saying, that he doesn't understand the First Amendment, and criticizing him in this small community and it's not to prejudice Judge Miller, but to prejudice the community. And in Levine, the court said that courts have a fundamental interest in ensuring the integrity of the judicial system, and it applies to both prosecutors and defendants, and that the integrity threat by throwing mud against each other is significant. So in Levine, the court said it's proper for a court to issue reasonable restrictions on attorneys in a specific case. And that is exactly what Judge Miller did. He said, you two can't talk disparagingly, or the prosecution and defendants cannot talk disparagingly against one another in the context of only this case. The other thing Levine said is what they don't want to encourage is attorneys to create a circus-like environment, which is what is going on here. Boulder City is a small city. You go on Facebook, you go to the newspaper, and you start calling the district attorney an idiot. You start saying he doesn't understand the First Amendment. It's not beneficial to the case, and it's not really protected speech with respect to that case. He had every right to go to the, I think it's a confirmation or the whatever with Mr. Morris, and say that he didn't agree with it. He couldn't talk bad about him in the context of this case. So is there a serious threat under Levine? There is certainly a serious threat here. The fundamental interest in ensuring integrity of the judicial system is at play here.
Can I ask you something?
Absolutely.
Looking at that, the activity poses a clear present danger. Now you're saying that it is, I think it prejudiced the community. I can't remember the word that you used, but why do we care what the community says? It really, Judge Miller is the one to decide the case. And unfortunately, we judges, we upset, I always say we upset 50% of the people all the time in our courtroom, but I guess if the community is upset, well, they're upset, and the issue is whether or not it causes an issue with prejudices the judge. And I have to say the Scarfo case, I'm just reading it now for the first time, but that was kind of my thinking, is that, hey, we have to think above that. So why do we care what the community thinks?
And I think you'd go to Levine for that, is that the community has a perception of how government officials, prosecutors and defendants should conduct themselves. And let me read you a quote from the concurring opinion in Levine. Respect for their profession and the integrity of the judicial process should be sufficient to deter the type of conduct that makes gag orders directed at lawyers necessary. Unfortunately, this required level of professional conduct sometimes does not exist. Bar associations appear to be incapable of securing it. So, and it's in Levine's in the holding by Judge Berzon as well, is that there is a relevant community issue that the community has to feel secure in what's going on in their courts. Calling people idiots, saying a prosecutor doesn't understand the Constitution. It doesn't serve any purpose. There are better ways in the context of a specific case. And that's what Judge Sneed was saying here, was that respect for the profession, it's important here. It's important for people to conduct themselves within the rules of professional conduct, which takes you back to the professional rules of conduct on prohibition, fairness to opposing party. And a community can put pressure on a judge in a specific case. If the information is getting out there and it's becoming, disruptive, a circus-like atmosphere, it could influence them. And the important thing is that the defendant gets a fair trial in the criminal case. So at that point, the focus comes on how do you guarantee a fair trial without prejudicing the tribunal? And that's what Judge Miller was careful with in his order, that you can't disparage the tribunal, you can't disrespect the tribunal, and you have to be fair to opposing parties and counsel. So I think if you read Levine, and I understand your argument well, and I have not read Scarfo either, I got it last night about 8 o'clock, that in Levine, the binding law on this court in this case, it says there is a clear and present danger to this type of activity in the cases. And do you have any further questions on that?
Well, you're going to go through the other?
Yes, I was leaving the serious threat.
Well, okay, and then you were on the order is narrowly drawn.
Okay.
I will be honest with you, when I read that last sentence, I was concerned about it being overly broad. For example, it prohibits all counsel from engaging in extrajudicial communications that in any way disparage or otherwise comment on opposing counsel relative to this case. I mean, if you take it to the extreme, Mr. Stubbs could go home to his wife and disparage counsel all he wants, Mr. Booker or Mr. Morris, and he could be in violation of this gag order.
And so if it was more narrowly tailored to, say, public communication, Facebook, YouTube, newspapers?
Well, I didn't want to craft anything. I just would tell you that when I read that, that was the first thing that came to my mind, is that Mr. Stubbs could go home to his family in the privacy of their own home, and he could call Mr. Morris an idiot, say he doesn't know anything about the First Amendment, and then he would be in violation of this order. So I was concerned about it.
Okay. Because I think the order is narrowly tailored in that, according to, the case law on this focuses on when parties are drawn into these gag orders or witnesses. And the court has never drawn that distinction. The court has always said that if it's limited to the attorneys in the case, the ones that uphold the gag orders, that's sufficient. And I understand your concern taking it to the extreme, but I think other courts have held that up as being narrowly tailored. That as long as you're limiting to the attorneys in a specific case for that time period. Oh, I was just assisted by. So here's what it says. This is Judge Miller's order on page 5. Continued public comments. So it specifically says public comments. This is on line 6. Continued public comments regarding opposing counsel would just escalate the disruption and prejudice of these proceedings. Consequently, a limited restraint on extrajudicial communications is warranted to maintain the goal that all parties to this matter receive a fair and impartial hearing of the case, free from prejudicial publicity. So the order is limited to public comments and...
Well, I was looking at the last sentence that says, therefore
Yeah.
it is ordered. And the order is, it is ordered that all counsel are prohibited from engaging in extrajudicial communications that in any way disparage or otherwise comment on opposing counsel relative to this case.
So I'm sure if Judge Miller could move one word down, it would be extrajudicial public communications, which is implied in the paragraph above it. Reading the document as a whole, it is only prohibiting public comments because it says continue public comments. So perhaps it could be crafted to include that word, or Your Honor could order that, but then it would be narrowly tailored pursuant to the current case law.
Okay, can we talk about number 3, the less restrictive, there's no less restrictive means available?
Quote from Levine, prior restraint gag orders are a highly effective remedy to avoid excessive trial publicity. That's what Levine said. That a gag order was the less restrictive because it is a highly effective remedy to avoid excessive trial publicity. That is what the Ninth Circuit has stated that this Supreme Court adopted. That these gag orders, when they're narrowly tailored properly, they are effective. I don't know how else you could do this less restrictive than to just prohibit the prosecutor and the defense counsel from making public comments that are disparaging to one another. It's certainly narrowly tailored, and it would be difficult to craft something less restrictive in that situation, and it's in complete compliance with what Levine says, which was adopted by Johansson. Any other questions on anything else that was said?
Well, I'm just listening to everything. I listen fully to Mr. Stubbs. I'm gonna listen fully to what you have to say.
Well, I think the issue is much simpler than how Mr. Stubbs has framed it. I mean, I'm not prepared to respond to, not up to date on Mormon church hierarchy or how these things are operating, or personal allegations or personal. All that I can tell you is we were retained to represent the city of Boulder City. We used his client's facts in our motion, to be fair. And as you know, in a summary judgment motion, the facts that you provide are the ones most favorable to the non-moving party. And all we did was cut just a brief section out of that was supported by his client's deposition. And we came forward with this order that I believe meets the Levine and Johansson standard. And I don't think Gentile is in play in this case. If it was, Johansson would have referred to it. And the Ninth Circuit has still not overturned Levine and remains one of the circuits that has a more restrictive standard on this type of speech. So unless you have any other questions, I'll rest on that. Thank you, Your Honor.
Stubbs?
Judge Miller might as well be singing Cher right now. If I could turn back time, if I could find a way, because that's exactly what he's doing with Levine. A 1985 case. If he could turn back time to Levine, maybe it would be okay. I still say it's not. And Craig Anderson is not fulfilling his responsibility for candor to this court. Let me read you the facts that were adopted by Judge Miller in his response. On June 8, 2016, several Nevada law enforcement agencies were conducting a crosswalk enforcement activity where officers cited drivers who failed to yield to a decoy pedestrian in the crosswalk. Guess what? My client never said that. Okay. During the activity, Hunt blew through the crosswalk, almost struck the decoy, and subsequently received a traffic citation. Where in the world has my client ever said that they, quote, blew through the crosswalk, almost struck a decoy? He did say that he received a traffic citation. Hunt, after thinking about the disgusting activity, he did call it disgusting, returned to the crosswalk with the intent of walking back and forth in the crosswalk until infinity. He said that. Upon reaching the crosswalk about 40 minutes after receiving the citation, Hunt, without looking for traffic, darted out into the crosswalk. He never said that. Forcing vehicles to abruptly stop to avoid hitting him. That's a direct quote from the police report. A direct quote. After Hunt's third trip across the crosswalk, Sergeant Glenn, who had no knowledge of Hunt's prior traffic stop, decided to contact Hunt to determine whether he was intentionally interfering with traffic, i.e. a crime. Did my client say that? No. These are direct quotes from the police report that have been adopted by the judge. The police report. I.e. a crime? Do you think my client would be accusing himself of a crime? Ridiculous. Ridiculous. Even more ridiculous is the next. Or whether he was a danger to himself or others, i.e. mentally ill, intoxicated, or on drugs. Judge Miller, adopting the police report and the deposition of the police officer, not my client, he adopted those facts. Verbatim what was put in the motion for summary judgment. This was not fair to my client. It was not right. And Judge Miller adopted them. Do you think my client thinks he's mentally ill, on drugs, or intoxicated? Do you think my client's accusing himself of a crime? That's what it says. We could go on, but more than half of this is quoted directly from the police report adopted by Judge Miller. It's just baloney, what Mr. Anderson said. It's not candor to the court. It is not true. And he drafted it. Now, if we could turn back time, Dominic Gentile, he specifically went after the prosecutor in a forum much greater than Boulder City, much greater. That got national press. National. Here we've got the Boulder City Review, my Facebook, and my YouTube. And the Supreme Court upheld it, cheered him on, and specifically talked about its importance for the pure political speech. Of course they want to ignore Gentile. Of course. But Gentile said some very important things. Very important. I'm going to quote from Brown here, where it says, Brown specifically discussed the pre-Gentile Ninth Circuit test involving the regulation of trial speech of Levine. Brown talked about Levine. And then Brown says, and I quote at 427, Gentile appears to have foreclosed the ability of the Levine test. Well, actually, they say the clear and present danger test, but I put Levine test in brackets, to the regulation of speech by trial participants. The Fifth Circuit recognized that with dealing with attorneys, the Levine test was overturned. Dealing with attorneys, okay? Also, specifically from Gentile, there's a spot where Gentile, just one moment. I'd also note, Third Circuit, Fifth Circuit twice, Sixth Circuit, and 11th Circuit have all adopted the Gentile test dealing with pretrial publicity and gag orders of attorneys. All these circuits have. All of them. And Johansson was not dealing with the attorneys. The attorneys were not challenging it. They were the trial participants, and the quote is, of their own case. It's distinguishable. It is completely distinguishable. Now, Craig Anderson was also not showing much candor to the court, because not only did Morris appear in the December hearing, he argued the case. And guess what he did? He didn't argue the facts. He didn't argue the law. He argued the morals. We had experts dealing with how everything was not authentic. We had all those things. We had everything. They didn't offer one expert. He declared it a conspiracy theory and then went to the person that is subject to him religiously and pointed to Mr. Stubbs and says, what Mr. Stubbs does offends me because he's disparaging our great police department. Now, is that a lawyer talking? Or is that his ecclesiastic leader talking? Because he argued the case. He also attended the First Amendment hearing. Interestingly, he doesn't do anything else. Gary Booker does practically everything, and I'm not aware of one instance to where Steve Morris has attended or argued anything else. But when there's finances on the line dealing with the civil suit, and when he can use his influence as an ecclesiastic leader, he sure shows up. Now, they say, not good for the community to see this. Clearly from Gentile, that is not true. Gentile says the exact opposite, and I'm not going to repeat myself. But Judge Miller says this is not good for the community to see this. And the United States Supreme Court in Gentile says, calling into question the motives of a prosecutor is exactly what we need and an important check on our government. Calling out allegations of corruption in police departments is exactly what we need, an important check on the government. Judge Miller's wording directly contradicts the United States Supreme Court. And again, there's no jury here. It's just Judge Miller. Him trying to control the speech into the community, that's why he called me on that Monday and threatened me to shut up my client's father, or else he would include him in the gag order.
Okay. Well, I'm not here to decide whether or not that's true, and clearly Judge Miller disputes that, and I appreciate that but I'm here just to decide your petition for writ of mandamus.
Yes, and Your Honor, they also say that I'm saying that Steve Morris doesn't understand the First Amendment. I've never said that. I've said he doesn't care about it. I'm questioning his integrity. And he's a prosecutor, and he's a public official, and that's important. And any other prosecutor that does that, I do that too. Because they should not be violating the First Amendment rights of the citizens. And I stand by that. And I never called him an idiot. I specifically said, after the fact, the gag order prohibits me from calling him an idiot, so I won't. Those are my exact words. You can watch the YouTube video. It's attached. I never called him an idiot. I specifically didn't. I wanted to. I probably would have if there wasn't a gag order, but I didn't. Fact is, he's way out of bounds here. Way out of bounds. And relying on Gentile, it is my duty to call it out. In the small community that we're in, with my Facebook and with my YouTube. That's all I'm doing. All I'm doing. Dominic Gentile called out the prosecutor and the police, and the state bar tried to exercise their prior restraint and told him he couldn't do it. The Supreme Court made a decision and said he could. That is not a proper exercise of prior restraint. 5 circuit courts agree and adopted the Gentile standard. Gentile itself does not adopt the Levine standard, specifically said that the clear and present danger standard is not the proper standard, which is the Levine standard. They don't say Levine, but they specifically mention the name of the standard. With attorneys, it is a different rule. And there's reasons for that. It's important. We're different than anybody else. We're different than other trial participants. And if there was a jury, there's no way I'd say anything. How many cases have I had that have had juries? How many times have I called out those prosecutors, even though I wanted to? 0. Because that's improper. I believe in justice. That's not justice. That's subverting justice. But when there's no jury involved and there's a judge, and the Supreme Court specifically says that it's our responsibility, I honor that. And I look at Scarfo. There's no jury, no foul. And I look at the narrowly tailored. No way is this narrowly tailored. The Brown is narrowly tailored. Your Honor pointed out how it could be narrowly tailored, but even if it's narrowly tailored, it's not the least restrictive means. Because the method of my communication is clear. Very clear. Do you know what actually, I think the only thing that would be possible here for the judge to say, the only thing that would be possible is if the judge said, I'm concerned that you might tell me things, then I want to hear that in court, in trial, or in briefs. So what I want you to do is I want you to restrict your speech to Facebook, where I can click and say, I can't see this, and to your YouTube, and I won't look at those. That would pass the narrowly tailored test. That would be the least restrictive means, if that's what he was trying to do. But that's not what he was trying to do. His own words. It is not good for the community to see this. He is specifically trying to preempt speech to the public, criticizing his LDS Stake President, the city attorney, Steve Morris. He admitted it. That's what he's trying to do here, and that's what's wrong. Your Honor, they can't turn back time. 1991 Gentile, United States Supreme Court, trumps Ninth Circuit Levine any day. even if Johansson adopts it for the purpose of trial participants in their own case. Doesn't make a difference. In either case, I still win. It's just wrong. It violates my First Amendment rights. Thank you.
Thank you. Counsel, I want to write a decision on this one, all right? I will say, though, Judge Miller, with as much respect as I've got for you, I'm a little bit concerned about how broad that order is, to be honest with you.
It was not intended to be, Your Honor, so
Okay, well,
I appreciate it's within its four corners, so.
okay, well, I'm not chiding you with respect to that, but I could tell you this in a way, it's injunctive, and drafting injunctive relief orders, I could tell you, are tough, because if you are trying to restrict conduct, you have to really be very narrow. So, but I am concerned about how broad it is. But I want to write a decision on this, okay? And I will try to get it out as quickly as I can. It's an interesting issue for me.
Your Honor, I have just a housekeeping matter. This is a personal concern. The way it's captioned, I don't know how that, and I'm not sure that this was not intentional to name me individually, but I don't know how that affects my credit when credit companies review cases. And
Can we amend the caption?
Of course, Your Honor. I had no intention whatsoever of doing anything individually. I tried to. There was the Associated Press and Judge Scotty, and there were some other things I saw. This is the first time I've ever written one of these or done anything like this.
Okay.
So if you want to amend the caption to the Boulder City Municipal Court, I believe Judge Miller's name should be on there with his capacity.
I don't think he has a problem with his name being there, but that he be sued in his capacity as the Boulder City Municipal Judge. Is that-
Correct, yes.
And in fact, I did correct that in my reply. I specifically said that, because that was never my intention.
Okay,
I don't wanna
well,
do wrong.
technically you can't amend the caption without leave of the court, but I'm going to grant the defense request that the caption be amended to reflect that it is you, Mr. Stubbs, suing Victor Lee Miller as in his capacity as Boulder City Municipal Judge. Will that,
That's fine.
Yes,
Thank
municipal
you.
court judge, yes.
right,
Yes.
okay. I'm going to grant that.
And Your Honor, if I could just, bring your attention to the statute that says that with these specific First Amendment cases, your order has a timeline of 30 days from date of service to Judge Miller.
And I would just like to object because the statute specifically provides that he has to have that statute and request on the caption when he initially files his petition.
Okay, well, I will go ahead and look over everything and get you out a decision, and I'm gonna put this ahead of everything else that I've got on my desk. Okay?
Thanks, Your Honor.
Because I know it's contentious, you guys need a decision like now. Okay?
Thank you.
Your Honor.